Hello, welcome everyone to Navigating the New Normal Remote Work Challenges. Obviously, I assume every single person on this call has been dealing with some of these types of challenges for the last few years, but we thought now, at this point, with the pandemic waning, it would be a good time to kind of regroup and talk about some of these legal issues. So hopefully that is what everyone was anticipating today, and that you are all here in the right place. For those of you who I have not spoken with before, my name is Jordan Schwartz, and I am here with my associate, Darius Rahani Shukla. Just a little bit about me. I've been at the firm since we started, which at this point has been around 8 years or so. Time really flies. And I do everything only in the employer-employee context for employment law. When Darius introduces himself in a few minutes, you'll see that he also does OSHA, so he has more of a specialty than I do. But I just really every single facet of employment law, whether it's FLSA, ADA, FMLA, Title VII, many of those we'll even mention today in the context of remote working. And really anything, all this type of counseling for when employers call us and find out, hey, to ask Jordan, what are we doing about remote work issues? I counsel employers on all sorts of advice on how they can best deal with their employees in these types of situations. The agenda today, I will just outline quickly the general costs and benefits of a fully remote or a hybrid work environment. Then Darius will jump in. He'll talk about some of the challenges with monitoring and reviewing employee performance. That's really one of the big issues with remote work, with having a remote workforce. Darius will then talk about the legal implications for employees who work remotely in states other than the state in which your company may be based. And then finally, I will wrap up and talk about unique legal issues related to remote workers. So as I said, I'll start just kind of a general discussion point here about the costs and benefits of a remote or hybrid work environment when dealing with both employers and employees. We have, listed just a few here. You'll of course be able to come up with many more costs and benefits that are tailored to your specific situation at your company. But for the most part, generally speaking, the benefits from an employee perspective are, to put it simply, for the most part, employees love it. At least some type of hybrid situation where they get the opportunity to choose whether or not to work full-time remote or part-time remote. Studies have shown employees show higher productivity. Certainly, often they have a better work-life balance. I mean, that's not always. Of course, with remote employees now, you have some situations where employees are working much later. There's really not a clear demarcation between a work day and a non-work a day, or hours in a non-working hours. It used to be, for the most part, you're in your office 9 to 5. Now I know I work remote a lot, and I am doing a lot of work from 5 p.m. till midnight or so, and that never used to be the case. But from my vantage point, I'm home and I see an email from a client and I want to get back to return the client's email. So that dovetails into the next one. Is it a healthier lifestyle? Most employees, maybe not attorneys, but maybe most other employees may say yes. Of course, it's another employee benefit that they don't have to commute, and I'll actually get to in a minute how that could be a benefit for employers too. Some employer benefits, broader candidate pool, you can potentially be looking all over the country for employees instead of your specific geographic region. You might get the benefit of the employees who are working more effectively at home. If you have a big office and you are purely remote, you can save a lot of money with smaller or even no office space. Back to the broader candidate pool, if you're recruiting employees from other states or other cities, you may be able to save money and pay a lower salary, or you can even pay a lower salary because some employees have indicated a willingness to take a lower salary in exchange for being able to work remotely. Studies have also showed that employees, you retain employees more if you allow them to work from home, and that ends up saving you costs by keeping your employees longer than not having to recruit and onboard other employees. So in general, the studies more often than not show that companies can save hundreds or even thousands of dollars per employee in terms of reduced overhead costs, whether that's rent or lease costs or less utilities you're spending money on, or other resources that you typically are using for in-office employees. That, of course, does not mean there are not costs to all of this. There's many costs. And again, this is just a sample. You know better than us in your specific situation and the context of your own industry what some of these costs may be. But of course, there's communication gaps for employers and employees. That may be more so for new employees. As I said, I'm going to introduce Darius to you all in a minute. He is a relatively new associate at Conn-Maciel Carey, so he might be able to tell you his own perspective of how difficult it was for him to be onboarded when we were not all in the office every day. Similarly, the lack of social interaction for employees and lack of team building. And that also, dovetails right to the lack of collaboration and brainstorming. I know some of my partners, years ago, we would walk by each other's office and say, hey, come in here. I'm thinking, I'm toying around with this new legal theory. What do you think of it? Now if I want to do that, I have to start a Teams call or send an email or a text. And, am I less likely to do that now? And are we losing out on any of this sporadic, spur of the moment, collaboration that could be important? Of course, ergonomic issues, if your employees, that's a cost for employees that they might have difficulty with their new work setup at home. Their chair might not be conducive. That also, of course, ends up being an employer issue. You want your employees to be healthy, and if there are things that they're doing at home that are detrimental to their health, you hate to look at that in terms of dollars and cents, but that is actually a cost issue for employers. And you hopefully all know this by now, and it goes a little bit against common sense, but if an employee is working in their home office and they have some sort of accident that actually could be a workers' compensation issue that now an employer has to cover through their workers' compensation program. So that's another issue that you might not think about right off the bat, but that certainly is a cost. An issue that I assume you do think about right off the bat is the difficulty in evaluating performance of employees, not being able to see when they come in, when they leave, actually, be hands-on for evaluating their work product is quite a big difficulty that a lot of employers have struggled with. And quite frankly, when employees are not performing well, that's when the rubber meets the road, and we get a lot of calls asking us, what do we do? This employer is not performing well. We're trying to figure out if it's a remote work situation, or if it's just a general employee performance issue situation. And then the one other one I wanted to mention that's not listed here, I had mentioned commuting time, that employees love that they don't have to commute, but also, trying to be environmentally conscious, employers can also benefit from reducing their carbon footprint by having their employees commute less. Again, not a benefit that you often think of, but it could be a good benefit for the employer. But back to the costs, the last one I've written here, and this is a huge cost: the potential difficulty maintaining confidentiality of company information and related security concern. Those security vulnerability concerns, where employees at their home office may be more susceptible to hacking or phishing attempts, are really a concern. And you do need to make sure you have IT protections both for that and for the confidentiality of company information issue. Those are two separate but related issues that I assume most people have thought about here. But if you haven't, that is certainly something you want to consider. And then the final issue I'll mention before I turn it over to Darius is the cost of potentially having to apply different state laws to your workforce. And I will talk about that more later, and Darius will as well. But that also is a cost to have to potentially research, or use us or other lawyers to research what your legal obligations are for different states, and then to apply them to different employees, some states which might have more generous laws. Again, we'll get into that a little bit more. This was just meant to be a little bit of an overview. And with that being said, I'm going to introduce Darius, and for the next few topics, so he can discuss them in more depth.
Hi, everyone. As Jordan mentioned, my name is Darius. I'm an associate here at CommonwealthCA, and I work on both the OSHA practice area and the employment practice area, which is mostly what I'll be discussing today. So the topic I wanted to start with talking about is monitoring employees and reviewing performance. Historically, monitoring employee efficiency and productivity was a long-standing, very basic practice for employers and managers. Managers could check in, they could poke their head into an office, see who was working, seeing who was on their phone, ask about assignments, generally see where people are and where they're working. However, now it's obviously not the case. So employers who have a remote workforce or even a hybrid workforce can't necessarily monitor employees the way they used to, but obviously that's still an important role of an employer. So today, what some employers do is they have access to a variety of technologies that can help them monitor employees as they work from their homes. For example, and an interesting, a majority of employers actually use these types of technology and certainly have access to them. But for example, they can log keystrokes, see what their employees are typing. They can take screenshots of employees while they're on their computers. They can record mouse movement, as I think a lot of people who have worked with your sort of external IT company can see that the IT company can log in to your computer, and you can see them working on your computer right before your eyes. Similarly, employers can have access to that same kind of technology. Point being, employers will always have the opportunity to kind of monitor their employees and see what they're doing in a lot of cases when they're doing it. But the development of these types of surveillance technology and the deployment of these kind of technologies inside an employee's home or on their employee's personal devices, like a phone, obviously isn't without legal and practical risks, a few of which I'm going to discuss next. Typically, at work, employees don't have a reasonable expectation of privacy at their employer's workplace outside of the obvious places. An employee's in a bathroom, employee who's working in the break room certainly has this expectation of privacy, and that means they get to expect that their employer isn't listening in on their conversations. However, obviously, an employee who's working from home, who's working in a remote workforce, doesn't have those same sort of steps away from their usual workforce. Under federal law, the Electronic Communication Privacy Act allows employers generally to have the right to monitor employees as they perform their work. The act permits employers to monitor employee activity on employer-owned devices or electronic systems. Basic examples being your computer, your phone. Federal ECPA doesn't require notice of or employee consent to such monitoring. However, some states, an example being California and Illinois, require employee consent to monitoring, and others, Delaware, Connecticut, just require notice of that monitoring. Importantly, under the ECPA, employers are prohibited from monitoring employees' personal phone calls, even if made using company-owned equipment. However, it does permit employers to record employees' work-related calls with clients or customers, provided there is consent from at least one party to the conversation. On this, as I'm sure you're aware, a lot of states have their own requirements for obtaining consent. A lot of people might have heard of the one-party or two-party consent laws, meaning that for a conversation to be recorded in some states, just one party needs to consent to the recording of that call. In other states, both parties need to consent to the recording of that call. Key to employers is they'll want to make sure that anytime they're monitoring or recording employee conversations, they're also complying with the law of the state in which the employee is employed. As I mentioned, the state laws on employee monitoring there are a variety of state laws on employee monitoring. New York, Connecticut, Delaware have already enacted laws that, as I mentioned, require employers to notify employees of their monitoring activities. But as remote workforces and hybrid workforces become more common, some legislatures have taken notice. And in California, they introduced the California Workplace Technology Accountability Act, which would impose real significant restrictions on the use of human research technologies, like the key logging or screenshotting that I discussed previously, on employers. And they've enforced that through a strong private right of action. This is key because it means employees can sue their employers. That act would prohibit employees from monitoring workers when they're off duty or on personal devices or in private areas. It would also prohibit employers from using technology that monitors workers' facial recognition, gait, or emotions, and it would allow workers to view and correct any data collected about them through monitoring. So a proactive employer who wants to try and stay ahead of potential employee monitoring limiting laws should keep in mind three main principles. The first one is necessity. Employers who want to monitor their employees should make sure that they're only providing remote employees with equipment and devices necessary for the performance of their job duties only. Secondly, employers should be careful to promulgate employee monitoring policies that limit monitoring to the employee's scheduled work hours only, meaning they're not monitoring what an employee is doing after work hours or even during a break and sometimes. And finally, when employers are using some sort of these surveillance methods, they should make sure they're using the least intrusive means available for monitoring quality, performance, productivity, or security. If on a basic level, if an employer wants to monitor one of their employees to make sure they're getting their assignments on time, they don't need to have a security camera watching that employee all day long. The employers should just make sure that they're only using they're trying to avoid being as intrusive as possible. Another really important issue that employers should consider when they have a remote workforce is how to manage their employees' performance and discipline. Remote employees are still expected to comply with company policies, meet performance expectations, and face discipline up to and including termination when they fail to meet their required standards. Even without face-to-face meetings or in-person conversations, appropriately managing remote employees is extremely important for any employer to defend against claims of discrimination, harassment, or other unfair treatments in some sort of future dispute. The key part that employers should be aware is they still need to maintain timely, thorough documentation of their reasoning in any sort of employment disputes. Employers and managers should understand that performance management and discipline has to continue with the same degree of formality in remote work, in a remote work setting, even if the method of documentation changes. For example, where previously an employer might use a handwritten note or a typed note that they present to an employee, now they need to use need to make sure they use documentation by email. Employers should also ensure that their managers have all the tools they need to remotely evaluate, review, and discipline their subordinates, and that they're trained in any new technologies or systems used for those purposes. On the other side of it, it's really important that employers make sure that the same is true for employees. Employees need to still have the same ability to respond to make complaints or compile investigations. Managers should be trained to recognize that informal remote complaints might look different to previous complaints, where a prior employee might go to their manager in person, meet them in the office. Now they might just make a complaint by an instant messaging system. And the employers must make sure that those sort of complaints are still immediately reported to the appropriate individuals at their company.
On that note, I'm just gonna step in and say one thing. I know for years in drafting, let's say, harassment policies on behalf of employers, we always made sure to say that we have, all of our supervisors have an quote unquote open door policy. Feel free to pop your head in at any time, so you can, voice any concerns that you have about your treatment in the workplace. If you have those types of policies in your employee handbook, you don't need to get rid of them, certainly, but if you do have some type of remote or hybrid workforce, you do want to amend them slightly. They could still even be called open door, but you want to make sure that at least you explain and say something to the effect of, if you work remotely, our open door policy still applies, and feel free to reach out via Teams, phone, email, text message, whatever the case may be. Because again, if you haven't done that right now and you read your employee handbook and you do have remote employees, it's going to look a little bit, out of date. An employee theoretically could bring a harassment lawsuit and show that as an exhibit in court to say, Your Honor, I didn't know this open door policy applied to me. You can read by the clear language. It only applies to someone who's actually in the office, not me. So, those are just the types of things, we think about as, when we're thinking about defending you from a potential harassment or discrimination claim. But that's why we wanted to bring these issues to your attention about how to kind of revamp ever so slightly your current policies and practices to make sure they apply to this new type of workforce that at least some of you on this call have. Sorry for interrupting, Darius.
And interestingly, remote work hasn't actually slowed down harassment claims against employers. Some surveys report significant increases during and after the pandemic in harassment claims, which to some might seem a little bit counterintuitive. Previously, most people would have thought that those sorts of claims would only come from in-person employers. But potential causes, as I put here, are one, heightened stress, and sometimes trouble deciphering tone in email, text, and chats. For example, an employer makes communication to an employee via any of those sort of written communications has little control as they've ever had on how the employee actually deciphers or reads that email, text, or chat. In a conversation, an employee might understand tone, might understand where an employee is trying to be warm, give helpful advice, whereas an employee who's having a bad day might read an email that's supposed to be giving constructive criticism in a much more negative manner, and as a result feel more adverse to their employer than they had were they to be working in an in-person office. So there are a few steps that we think are important to minimizing harassment claims. In general, employers should really consider the following. First, it's really important to revise policies to apply to remote workforces and conduct training that reflects harassment scenarios in remote workplaces. They should make sure that their managers are aware of what harassment claims might look like when they're dealing with employees that they might never have met in person. They should also minimize obstacles to reporting by adding multiple avenues for reporting concerns. If you're an employer who only communicates with their employees via email, might consider enacting a policy that notifies employees of where to report concerns, or directing a contact person who's in charge of that. Additionally, it's important that employers acknowledge that some workers might be unclear on what to expect from reporting concerns if they've never met their supervisor or HR person in person. So employers would be wise to put themselves in their employees' shoes and think about where they would want to where they might think would be an appropriate place to make any sort of report any concerns. And importantly, if there is someone that employees could expect to report concerns to. An additional issue that comes up a lot for employers who have employees working remotely is that for the first time they might not know where their employees are working, hopefully not. And importantly, they might not know the laws of where their employees are working. For example, having employers who have employees in multiple states just provides a lot of unique challenges that they wouldn't have considered before. An employee who works remotely might trigger the laws of the state they work in without the employer knowing. Some states and some laws require a threshold number of employees before a law is triggered. For example, in Massachusetts, there's a paid leave law, which requires an employer contribution if there are 25 or more covered individuals in the workforce in that state. So if an employer has 25 employees working remotely in Massachusetts and they don't know it, they'd be on the hook for making contributions to the Massachusetts paid leave law if someone applied for it. Whereas additionally, there are some laws, leave laws that I'll go into later, where an employee's presence by themselves is enough to trigger those leave laws. That any employees who work in that state get access to those leave laws, and as a result, an employer who denies their employees that leave would be conducting unlawful employment actions. And an important piece that employers should pay a lot of attention to is that states also treat hybrid employees differently from one state to another. Some states will require that employees work in the state for 50% or more of their time for a state law to apply, whereas other state laws depend on an analysis of where the employers that are making decisions relating to the employees are located. There's a wide variety of state employment laws that can affect unknown employers, including many that might be foreign to them because they're not in the state that previously the employer was physically located in. For example, there's background check laws, arrest and conviction record laws, biometric information, monitoring laws relating to overtime pay that we'll go into later, laws relating to whether employers need to pay wages and PTO, whether they need to pay PTO upon termination, what sort of break periods are available to employers, what sort of leave is available to employees, whether employers can have their employees sign non-compete agreements, and how employers need to treat workers' compensation insurance. Employees who work in some states will have access to leave that their employers might not be aware of. Examples are here. The examples are here: crime victim leave, voting leave, civil air patrol leave, emergency responder leave, maternity and paternity leave, organ donation leave, bone marrow donation leave, jury duty leave, school activities leave, school suspension leave, and military spouse leave. An employer who has an employee working in North Carolina might not know, but in North Carolina, employees who have children in school are eligible for 4 hours of leave to go to school activities over the course of a year. An employer might not know that, could unwittingly deny an employee that leave. And similarly, they might not be aware of things like voting leave or crime victim leave, which aren't unanimous among states. Additionally, different states treat business expenses differently. To one, the Fair Labor Standards Act, the federal law on this, and as well as among themselves. So as a baseline, the Fair Labor Standards Act requires employers to reimburse employees for expenses that they incur on their employer's behalf if the expense brings the earnings of the employee below the federal minimum wage. Whereas other states have more robust reimbursement laws that are a little bit more in favor of the employees. California, Illinois, and Montana require employers to reimburse employees for all necessary expenditures or loss or business expenses incurred by the employee in direct consequence or discharge of his or her duties. In those states, employers will have to pay more for the business expenses that those employees incur. Similarly, different states also have different requirements in relation to training that is required of both employees and employers. In these states, California, Connecticut, DC, and some industries, Delaware, Illinois, Maine, and New York City, sexual harassment training, training on sexual harassment protection and responses is required, and employers who aren't aware of that could unwittingly violate statutes. Similarly, having remote employees in different states can subject employers to more tax liability than they might have previously realized. For example, out-of-state employees could result in the employers having to file personal income tax returns in multiple states, and employers that subsidize home office equipment may need to pay personal property taxes in various states and counties. And on the most fundamental level, how much employers must pay their employees changes from one state to the next. Federal minimum wage act is $7.25 per hour, but different states have higher minimum wages than the federal laws, and some require their own postings. A West Virginia employer who employs a remote worker in Virginia or Maryland could be on the hook for paying much more than they realize because the minimum wage statutes in those states are higher than they are in West Virginia. Finally, as Jordan mentioned, some states, despite having employees who work remotely, employers still need to be aware of workers' compensation. Working remotely doesn't alleviate concerns related to workers' comp, as employees can still get injured at home. Some states will allow reciprocity with workers' compensation policies that employers utilize in their home states, where others might require additional coverage in the state where they have employees. So employers should, who have employees working in different states, need to check the workers' compensation statute in that state to make sure that their coverage applies, or if it doesn't, whether they need to get separate coverage. So, as you can tell, a multi-state workforce provides a wide base of potential legal issues if employers aren't careful. So the first step in ensuring that, of any sort of an employer is trying to manage their remote workforce and mitigate potential violations, or is to update their policies and handbooks to include remote work rules. Then it's important that employers are very careful about where their employees are located. They should document where their employees are located and where they're and what they're doing there. They should continue to keep track of where the employees live and make sure that their policies require notice of moves out of state before they occur. And they should make sure that they continue to verify where their workers are located. And finally, employers shouldn't be scared to say if there are states where employees cannot work. If an employer doesn't want to pay a certain minimum wage or follow certain leave laws, or there are any policies that they find aren't advisable to their business model, employers can state through a policy that their employees aren't allowed to work there. And then I'll turn it over to Jordan for a few more legal issues related to remote work.
Thanks, Darius. Okay, yeah, as Darius said, we're going to talk about a few other specific legal issues, and then we'll get to some of your questions. First, we're going to talk about the FLSA, the Fair Labor Standards Act. And it's interesting because an FLSA decision actually just came down at the Supreme Court an hour or two ago, so I haven't had a chance to review it. But it did say that employees who are highly compensated, and in the case of the decision, it was an employee with who made $200,000 a year, was still entitled to overtime because I believe he was paid daily instead of a specific salary. So even though the daily payment amounted to over $200,000, the employer still owed him overtime. And I'm mentioning that here because right now I'm going to talk about overtime issues. So employers under the FLSA, employer has the obligation to pay non-exempt employees for all hours worked if they knew or should have known about those hours worked, even if the employer did not ask the employee to perform the work. So let me just clarify here. We're talking about non-exempt employees. That essentially means hourly employees. Really, for the purpose of this discussion, we don't have to worry about salaried employees. If you pay anyone daily, then you do have to worry about this per this new Supreme Court case. So the second bullet point here that I mentioned, this rule applies even if the employer did not ask the employee to perform the work. So I've certainly had cases over the years where an employer calls me and says, well, someone performed overtime work. We're not going to pay it because we have a rule that says you're not allowed to perform overtime work. That, unfortunately, is a wage and hour violation, and it's much more prevalent here in the remote work setting. So just because you have a rule that says an employee cannot perform work, that's, for the most part, irrelevant under the FLSA. The FLSA says you are required to pay an employee for all hours that the employee works. You of course have other avenues to address someone who works overtime if they don't have permission to do so. You can discipline that employee for failing to adhere to a workplace policy, but you still need to pay that employee for the time that they work. And if they continue to violate, you continue to pay them, and then maybe you fire them. But it's never the right decision to not pay them. And again, that is very difficult here, where you are not shutting the lights off, let's say at 5 p.m. and telling your employee to go home. So on that note, I'm just going to read to you here, a few of our bullet points that we put down here relating to these overtime type requirements. One, in order to avoid running afoul of the FLSA, you want to do each of these things and more. One, review timekeeping policies and procedures to ensure that they clearly instruct employees to log all hours worked, regardless of whether they were scheduled or unscheduled. At the end of the day, again, Darius and I are always thinking from the perspective of how to defend you. If you do not have a policy that clearly instructs employees to log all hours worked, and then the employee has not logged all hours worked and then is claiming they worked 300 hours last month, and you're saying they only worked 150, you are going to have an uphill battle prevailing on your defense because you don't have a policy telling them what to do. So how do we know that their claim that they worked 300 hours is incorrect? You also want to review remote working timekeeping technology to ensure employees have access before and after their scheduled shifts so they can enter their time if that's applicable to your business. Likewise, where technology does not allow an employee to easily access his or her timekeeping system to enter the time worked outside of normal working hours, you should consider an alternate timekeeping system or some sort of method for capturing those hours. I mean, maybe you still do it old school and someone just writes it down on a piece of paper and scans that piece of paper to you at the end of every day. There's nothing wrong with that. It's just not as high tech as we see these days. But the point is to make it as easy for your employees to record their hours, which then in turn makes it difficult for them to bring some sort of unfounded claim against you that you have not paid them for all time that they've worked. That's really what all these bullet points are really getting at here. The next one is to provide clear guidance for employees who run into technical difficulties logging their time. So, employee A wants to log their time, but his office computer at home isn't working, or his network at home is down. What is the alternative? Is it marking it down on a piece of paper? Is it calling his supervisor and going through it one by one? If you leave it to the employee's discretion, they are going to say there wasn't a policy, and thus they had no opportunity to record their time. And again, then they will argue that their time is accurate. The last one is slightly different, but it's still kind of the same premise. Ensure that your company has a policy requiring non-exempt employees, again, that's hourly employees, to notify management if they believe that there's an error in their paycheck and that the company has a mechanism for correcting it. Without this mechanism, the law varies on this, but there are some states that say, oh, too bad, you made an error, the employee is entitled to that money. But if you have a policy, this is known as, I think it's called the safe harbor provision or something. If you have this policy about notifying management, and then the employee either notifies management or doesn't, but then you find out about it, you have a much, much, much stronger claim that you will be able to recoup any errors, especially if it's an overpayment. And again, I mentioned this on the previous slide, but I'd really like you to have some sort of clear guidance that says, if it's applicable in your company, that says an employee needs express permission to work more than 40 hours in a work week, and that a failure to obtain such permission prior to working overtime could result in disciplinary action. Again, this is only if this policy applies to you in your industry, in your business, and you don't want employees to work overtime. If that's applicable, you need some sort of policy telling an employee so that they know that their failure to get permission, it will result in disciplinary action. And then we can be clear when we're defending you that if the employee brings a lawsuit, we're not suing him, or we didn't fire him because he worked overtime. We fired him because he failed to abide by our policy. And that might sound like a subtle distinction, but it's actually, a very big distinction. We really like to argue failure to abide by policy. We certainly don't want to open ourselves to some sort of argument that we retaliated against someone for in retaliation for them expressing their rights under the FLSA. So it really is quite a big difference there. And if that is something, that is applicable for you, make sure you don't have employees, remote employees working in a state that actually has different overtime laws. Let's say you're based in DC, but you actually have an employee working in California. In DC, as in most states, the rule is you need to work more than 40 hours in a work week to be entitled to overtime. In California, it's if you work more than 8 hours a day, I think you're entitled to overtime. And then you get even double if you work in excess of 12 hours a day, or if you work 7 days in a row. I think Nevada also has the over 8 hours in a day is overtime law. We've written down here, Colorado, it's daily overtime only if it's over 12 or more hours in a day. Oregon is daily overtime if someone works 10 hours or more in some certain industries. So, as I think Darius mentioned earlier, most importantly, you need to be aware where your remote employees are. Then once you're aware of that, you can enlist legal counsel or otherwise figure out what laws may apply to your employees. But you can't do that unless you know where they are first. So you can't put the cart before the horse. The last issue I want to talk about here, before we get to a couple of your questions, is remote work as an accommodation. And this is one of my specialties, is the ADA. Under the ADA, which stands for the Americans with Disabilities Act, that covers an individual with a physical or mental disability, a history of having such a disability, or someone who is regarded as having such a disability. And the ADA requires employers to provide reasonable accommodations to qualified individuals who have an actual disability or a record of disabilities, if the accommodation is necessary for individuals to perform the essential functions of their job. And, because this comes up much more often, we're talking about this in the context of the ADA, but just note that also requests for an accommodation can come under other statutes as well. For example, and we saw this a lot with the mandatory vaccines, and either this happened at your business or you heard about it, there were lots of requests for religious accommodations. So employers who requested that you have a vaccine, someone might say, I can't come into work because of my disability, so I request an accommodation under the ADA. Or someone may have said, I can't come in because of my religious beliefs, and I request an accommodation under Title VII of the Civil Rights Act. So just know, while there are some minor differences, and we can get into that if you all have questions, for the most part, this analysis is the same, but we're just going to focus mainly on the ADA context. So this remote work as an accommodation, is always been a tricky issue. And the fact that now you have remote work makes it even trickier. It used to be everyone else was at work, and someone, if they were sick and had a disability, they asked for an accommodation to work from home. Now, what if a bunch of people are already working from home? It really might tie your hands to potentially deny the reasonable accommodation request, although there might be certain legitimate business reasons why you might do so. But let me just give you a little bit more of a background before we talk about specifics. So, reasonable accommodations are accommodations that are intended to remove disability-related job barriers to an employee's job performance. And an employer must provide a reasonable accommodation to an individual unless it is an undue hardship. And that's where kind of the rubber meets the road. Is it unduly costly? Is it substantial? Is it disruptive to your business? Does it fundamentally alter the nature of operations of your business? Those are some of the things that go into the analysis of whether or not an accommodation can be granted. As I mentioned, remote work has been historically and can be a form of reasonable accommodation under the ADA for employees whose medical conditions may prevent them from either commuting to an office or working in an office environment. So regardless of the law, as an employer, you are without doubt expected to at least consider permitting remote work as a potential reasonable accommodation under the ADA. And then the analysis is, does it allow the employee to perform the essential functions of the job? or does it create an undue hardship for the company? Those are really the two prongs. And when deciding whether remote work is an acceptable, reasonable accommodation, courts, of course, analyze this on a case-by-case basis. Some cases rule against employees seeking to telework. They say that in many jobs, physical presence in the workplace is absolutely essential, especially if a job requires teamwork or personal interactions with clients or supervision of work. If you're a hotel, probably not going to be a reasonable accommodation to let your, front desk agent or your bellman, work remotely. That just might not be possible. But, on the other side, some courts do require you to grant the accommodation in the correct context. What is basically non-negotiable is if you have evidence that an employee is not performing well from a remote setting, you can disallow the accommodation. Again, this gets a little bit more tricky though, if you have other employees who are still working from home, and then an employee who's requesting to work from home is denied. But if the fact of the matter is that he or she is not performing up to standards remotely, and let's say they were performing up to standards at the office, or even if they're not, you need the opportunity to evaluate them in person, then that is where, you are well within your right to say that accommodation will not be granted. We now can work and engage in what's called the interactive process. And we can have a whole hour discussion on this and come up with what a reasonable accommodation actually could look like. You don't just say, nope, sorry, no reasonable accommodation at all. You say working from home, either fully or partly, is not working. What else will work? And then you try to come up with a different reasonable accommodation. Right before I get to questions, here's just so you all see a list of our remaining 2023 Labor and Employment webinar series. This is our third one, so I think that means we have about 9 more. And we actually sometimes come up with even more when hot topics, arise at the spur of the moment. So we hope you'll sign up and join us for those. Also, anytime you have want to read about these issues, Darius and I like talking about them. We write about them. Feel free to read the Employer Defense Report, the OSHA Defense Report, the other blogs that we have. You can subscribe. There's no cost. We just provide this information for your knowledge. Here are continuing education credits that if you are someone who is taking the SHRM credits or the HRCI credits, this is information here that you might need. And finally, this is Darius and my contact information. Again, we like talking about these issues. We'll be happy to continue to talk about them if you email us, call us with any questions. And on that note, in the last few minutes here, I want to try to get to some of your questions. Okay, we're going to go up from the top, and whatever we can't get to, we will email you about. The first question is, would you recommend companies provide employees with a business need with a mobile device or just a phone stipend? If employers need to provide any equipment necessary to perform their jobs, an employee needs a mobile device, would a phone stipend suffice even if they are not providing the actual device? In my experience, you can really go either way. Darius mentioned the monitoring aspect. If you're providing the advice, I think you have much more of a potential opportunity to monitor. If you provide a stipend, just because you provide a stipend, I don't think you have that ability. But it also might be less burdensome to provide the phones and just provide a stipend. So, that's something we can talk more offline about if you want. I don't really think there's a right or wrong answer. I'll read the next one and then you can go to the one after. Would you suggest we update the open door performance management language to avoid claims of harassment, even if staff do have days in the office and only telework a few days a week? Yes, I would. Because taking it literally, I'm trying to think of an employee making a claim. He could claim that he was harassed on the day he was not in the office, and we didn't have a policy to address that. And sure, we could argue that, okay, and the next day you were back in the office and you could have got into someone's door. But I still think we want to be as broad as possible. So why not try to cover all our bases? So I would recommend opening it up, revising the open door policy, even in that situation.
And then I can do the next question. If you have several employees working in one state, but they all work from their homes, do you need to register each individual address as an office of the employer? It's a good question, but no, there's no requirement that you need to do that. So definitely don't need to do anything of that sort.
The next one, on the overtime rules. So with an employee who has scheduled hours and has been instructed to work them and no additional, if they work them and we have to pay them, are we able to take disciplinary action up to and including discharge? Yes, and that's what I was talking about. I probably wouldn't discharge the individual the first time. I might instruct them, just so you know, our policy is you are not able to do so. If you continue to violate our policy, we will have to terminate you. So let the employee know that they violated the policy, and any future violations would result in termination. That would be my recommendation. But yes, you are definitely allowed to take disciplinary action. That's the point of having the policy.
Next question. Is there a website that will give us all of the state's information? There's not one that I'm aware of. I mean, one thing that I think that is pretty helpful, if you usually go to a state's like labor and industry website for that state's government, often those are pretty informative. But I don't know of one that's like comprehensive for all 50 states or anything like that.
Yeah, and you want to be careful there. We've done work for clients where they tell us, oh, they call me Jordan, I have a new client who's now working in Florida. Can you, provide me the applicable rules and laws for that state? And I'll do that. And not that we're trying to solicit work here, but you really want to use a legal counsel to let you know all about all the applicable labor and employment laws. Just finding a website might not really be might not be as comprehensive as you would like. And quite frankly, I just don't think one exists. I know we do have some clients who have operations in all 50 states. So we kind of have some sort of working form that we've looked at and we've revised based on rules in each of the states. But also every January, different states' rules and laws change. Some are revised. There's some new laws. Some go out of date. Like minimum wage, for example. So be careful about relying on anything that's not as of February 22nd, 2023. And then is, what if the client the employee works for does not allow telework? And I assume that's in the reasonable accommodation context. And I don't like just saying, nope, we're not going to provide a reasonable accommodation because we don't allow telework. You should at least consider it. At the end of the day, the answer might be there's a reason we don't allow telework. And although, we are not required to provide your requested accommodation, but maybe we can let you work from home once a week, or maybe we can let you take extra breaks. But I don't want to just rely on your rule without engaging in the process. Other than that, I think that's all the questions. Again, feel free to email Darius and or me if you have more. And we enjoyed presenting this. We hope it was helpful and gave you some good information, and we look forward to presenting for you again soon. Thank you.